Mesdames et messieurs, c'est l'heure de...
Ladies and gentlemen, time has come for our inaugural lecture. And as I indicated earlier, I will say a few words to introduce our distinguished guest, Professor Yves Daudet. Professor Yves Daudet, Emeritus Professor of Paris I, Panthéon-Sorbonne. He was a university professor throughout his career, also in Bordeaux, in Martinique, where he was in residence, in Aix-Marseille III, professor there too, and several universities abroad, where he was seconded on behalf of the French Cooperation Service in Morocco, Côte d'Ivoire, and Mauritius. Prior to that, Professor Daudet started his career as a student, of course. He studied law at the Faculty of Law of Paris. He was a brilliant student. He presented a thesis, and it was awarded the Georges Sell Prize. I'm proud to say that because it's no coincidence. Georges Sell was a secretary of the Hague Academy of International Law, and as I indicated earlier, this may have been an omen, if you like. It no doubt had an influence or a bearing on the career of our eminent guest. He has also had administrative functions in Paris I, Sorbonne. So in other words, he has skills not only as a lawyer, a legal mind, but also as a director, a president, administrator. His activities and his teaching have always focused on international work. He conducted a number of missions in a number of states. He's also been involved in cooperation activities and has always set great store by university exchanges, academic exchanges, meeting professors and students from various backgrounds. In his career, he has been really, I think, distinguished by becoming the Secretary General of the Hague Academy of International Law in 2004. I believe that's right. Secretary General, 2004. He held that position for 12 years. He excelled in that function for 12 years. Very busy years. So busy that at the end of his term of office, he was elected president of the Curatorium of the Hague Academy. That happened in 2017. He's held that position since. Professor Daudet was also chosen by a number of states to sit on the ICJ as an ad hoc judge. He could perhaps also have been a judge at the International Court of Justice, elected by the states at the General Assembly, but there already was a French justice in place. So that is why this did not happen, but he was nevertheless given a place at the table as an ad hoc judge. He's currently an ad hoc judge on 3 cases pending before the court. It is an incredible honor for us today, for the Academy, for me personally, to welcome you, President of the Curatorium, to the podium today, Judge ad hoc, Professor and very, very dear friend. I welcome you to give your inaugural address on solidarity in international law. Welcome and thank you. Thank you very much, dear Jean-Marc. Thank you. Thank you for your all too kind words. As always, you are far too flattering. But I think that what this demonstrates is our true, genuine friendship between the two of us. We didn't used to know one another so well. I'd heard of you, and when I made the suggestion to the Curatorium to put forward Mr. Touvenat's name to succeed me in my position, I'd heard of you, I'd heard of your scientific reputation, which was outstanding, and it was an excellent choice. We've since got to know one another much better, and I found a friend. I really have found a true friend. What you said, Jean-Marc, and the way you said it, I think, was an expression of that sentiment, of that friendship. Ambassadors, dear colleagues, dear friends, many of you have really honored me by your presence. Thank you so much for attending this inaugural lecture. And dear auditors, dear participants, dear students, ladies and gentlemen, I have to say it's an immense pleasure for me to address you, and you will understand why as I come to the end of my speech in a moment. But first of all, I should perhaps explain why I have chosen to talk about solidarity in international law, even though this particular subject has been studied often, has been addressed very appositely, in fact. I'm not looking at my emails, by the way. just to be clear, I'm just setting the time to make sure that I don't exceed my speaking time. And there is also, of course, a clock up on the wall, so I shall keep an eye on that too. So, in terms of timekeeping, that's what I was doing. It's a topic that's been addressed most recently here, in fact, by Professor Rüdiger Wolfrum here at the Academy, excellently addressed by this professor. I don't want to repeat, therefore, what's been said so expertly by others. What I would like to do is take a slightly different approach. And I'll start from an observation. The world is changing. It's changing profoundly. It's changing incredibly rapidly. And international law has been strongly impacted by this change. First, I should perhaps say a few words about what we generally understand by solidarity in international law, and also explain how I propose to talk about it. In the interest of clarity, I would first of all like to rule out any comparisons with domestic law which does use the term solidarity, particularly when it comes to contractual liability, for instance. I'm referring here to mechanisms of systems of joint and several liability, which you'll find in the French Civil Code, or indeed the English formula of joint and several responsibility. James Crawford, as the ILC's Special Rapporteur on Liability, the International Law Commission's Special Rapporteur on Liability, James Crawford warned us against this type of approximation or confusion. He considered that caution should be exercised in the use of terms such as common, joint and several, solidaire, solidary, which are drawn from national legal systems. He guarded us against that. And in support of this argument, one may indeed note that these types of systems can be found in some very well-known treaties or conventions, such as the 1972 Convention on International Liability for damage caused by space objects, or indeed I could refer you to Article 139, subparagraph 2 of the UN Convention on the Law of the Sea, which relates to the principles governing a zone when it comes to liability for damage. So these are specific examples. They're very specific, precise examples, and they tend to concern activities that are carried out in areas which are outside of our territorial sovereignty. And therefore, these examples don't really add much to the development of the concept of solidarity. Basically, they are a matter of legal technique. They are a way of using liability law to settle a number of practical questions, which don't really have anything much to do with solidarity as we understand it here, the moral meaning of solidarity, the way in which we would understand it here today. So as we understand it here today, the term solidarity is well known in the legal scholarship. However, it is rarely mentioned in the texts in our legal instruments, and therefore at first sight I would query its status as a legal term. The UN Charter does not refer to it, does not use it, nor did the Covenant of the League of Nations. However, you will find this term in the Charter of the Organization of American States. I refer you to Article 3, subparagraph D, which does refer to the solidarity of the American states. And indeed, you'll find it in the Rio Treaty on Mutual Assistance of 1947, the Rio Treaty which speaks about the principle of hemispheric or continental solidarity. I refer you to Article 3, paragraph 2. But again, we don't find mention of it in the NATO Treaty, the North Atlantic Alliance Treaty adopted in Washington in 1949. The NATO Treaty does not talk about solidarity. The word is not in there. As for the International Court of Justice, unless I'm much mistaken, the court has never used this term in a legal sense, in a specific legal sense. The court has referred to it when reflecting the positions expressed by states. And as it so often does, it will quote the arguments advanced by the state, by the parties. So you can find a reflection of what the states have said. It will be reflected in that way. And also I could refer you to the Notenbaum case, 1955, where the term is used, but it's used in the, so to speak, ordinary or sociological sense, simply to explain the concept of nationality. The court here speaks about effective solidarity of existence, to illustrate the point of nationality. But again, as you'll see for yourselves, there is no specific legal connotation attached to the term in that use. So all in all, I would say that solidarity is generally replaced by related but not identical expressions such as cooperation, collaboration, cooperation and friendly relations, common goals, coexistence. In other words, words that contain the prefix co, which comes from the Latin cum. I think that that is the sort of axis around which these words will be constructed and how the word will be used, or how the words will be used. And that's why you have these ideas of community, of union, of common interests, etc., etc. These are terms that have been forged by multilateralism. These are rules applicable by all and for all. And so what we're talking about here is the enrichment of the legal nature of international law through erga omnes obligations, peremptory norms of jus cogens, and these are indeed well placed to strengthen the social bond, so to speak, and to create international meaning, sens international. I'm using here the terms used by Georges Sell, who was mentioned by Professor Touvenin a moment ago. So you see, I am very grateful to Professor Georges Sell. So solidarity, as I see it, is an attractive concept. Dare I say it, it is even a likable concept. I like the concept of solidarity. Solidarity evokes peace. It evokes a sense of well-being, and it's also flanked by a sort of reassuring sense of security. And I was therefore wondering whether, in these highly troubled, unstable international circumstances, the ones we currently find ourselves in, whether solidarity could perhaps have a place within that after all. I mean, could I perhaps even talk to you about it, about this concept of solidarity under the present circumstances? And if so, what would be the nature of this solidarity? What would the effects of this solidarity be? And could it reasonably be invoked in the context of existential questions relating to international law, arising from violations of it, or indeed challenges to it? So could we speak about all of this? In light of the above questions, I really feel compelled to start off by providing a brief overview of the current state of play, because what I'm going to say to you today is not necessarily what I would have said to you 2 years ago. There is a new factor, if you like, and I really feel compelled to foreground it before I continue with this concept. Once I've done that, once I've given you the status quo, the current situation, I will then examine the current criticism levelled at this international rule against the backdrop of concept of solidarity before saying whether and to what extent it can be implemented. So what's the current state of play? Well, international law is currently in crisis, we're told. It's all we ever hear. Whichever way we turn, everybody says international law is in crisis. But I personally don't think that we should sink into the depths of pessimism, especially not as I address you, ladies and gentlemen, you whose task it will be to put in place a better world than the one we are bequeathing you. So let's not be pessimistic, let's not despair, please. And especially not at this moment in time, when an ill wind blows, it has to be said. Now is precisely the time where we need to hold the helm of this ship firmly, and we need to make good use of this ship's sail. Perhaps I should say a few words. I mean, for lack of time, I'll just skim the surface. I won't be able to say anything that will come as a great surprise to you, but let me say a few words about the nature of these ill winds. Aren't they actually what's happening right now? Isn't it actually the opposite of the concept of solidarity? And there's no doubt that Russia's aggression against Ukraine is a particularly serious event. It has grave consequences, worrying consequences. The aggression, and I would remind you that it is a crime, was indeed qualified as a crime by the UN General Assembly in its first resolution adopted on the 2nd of March 2022. It was adopted by a very broad majority, 141 votes in favour, 5 against and 35 abstentions. The ICJ, for its part, decided or ruled that Russia should immediately suspend its military operations. It did through its order on provisional measures, dated the 16th of March 2022. Now, Russia has not complied with this order, and a dispute is currently pending before the court. Now, since I'm an ad hoc judge appointed by Ukraine on this case, I can't tell you any more than that. But suffice it to say that carried out by a state as important as Russia, and bearing in mind that it gives rise to a conflict that's been particularly destructive in terms of human lives, civilian losses, property, this relentless aggression really constitutes a formidable echo chamber, I would say. And that's what's worrying. An echo chamber which can but inspire copycat crimes to be committed elsewhere and by other states. I mean, if Russia's done it, why can't we do it? That, if you like, is the potential effect. Why not us? And that is, in fact, precisely what happened concurrently with this lightning military operation by Azerbaijan in Nagorno-Karabakh, which sent more than 100,000 people into exile, fleeing their homes. And here, too, several orders on provisional measures were issued by the court. There are difficult negotiations underway between the two states concerned. They're going ahead, but it's not easy, it's not straightforward. Parallel to that, you have a dispute currently pending before the court, and again, I can't go into the details of this dispute for the very same reasons as the ones I mentioned above, namely the fact that I have been appointed ad hoc judge. Then, let us take the example of Venezuela and Guyana. Provisional measures were ordered on the 1st of December 2023 at Guyana's request. In this order, the court prohibited Venezuela from undertaking any action that would alter the situation prevailing in the disputed territory. Now, the case currently pending before the court concerns a territorial dispute which relates to approximately, well, over a third of the territory of Guyana, to which Venezuela is laying claim. And subsequent to this order of the 1st of December, a commitment to conduct themselves in accordance with peaceful relations and in accordance with international law was entered into, fortunately, by both states. This was after Venezuela had abandoned its explicit or express threats to use force with a view to territorial conquest. And if that territorial conquest had occurred, or if ever it did occur, if the negotiations break down, well, it would be reminiscent, mutatis mutandis, of Russia's aggression against Ukraine. Finally, of course, I am thinking of the war that is unfolding in Gaza. I don't think the tragic elements of this war need to be repeated here. They continue, they worsen, they are accompanied by violations of international law on all sides, marking it out as a war of another time. I note that on 29 December 2023, South Africa submitted a request to the court under the Genocide Convention for the ordering of provisional measures to halt Israel's military operations. And as has been recalled earlier today, on Thursday and Friday, there will be pleadings before the court on this case too. I won't express my opinion. I do have an opinion on the grounds of this request, but I won't particularly go into that now. I'm not an ad hoc judge on the case, but I do not wish to express my opinion at this juncture on this point. So as you can see, I'm really focusing here solely on existing conflicts, all of which constitute very serious violations of the rules of international law, the rules of humanitarian law, without even necessarily drawing up an exhaustive list. I mean, Sudan, Yemen spring to mind, and without mentioning the threats, either real or imagined, that hang over other states of the former Soviet Union, the island of Taiwan, Hong Kong, the China Sea, the threats from North Korea. Basically, whichever way you look, you will find this in the same temporal space, the same unit of time, whichever way you look. It's a bit like a classical tragedy. And without the benefit of hindsight, it's always difficult to assess a state of affairs. But the current situation seems to me particularly serious because it calls into question fundamental principles which we thought were self-evident and agreed. And in particular, we have the problem of the paralysis of the institution that used to act as a guardian of these principles, namely the UN, the United Nations. The only body that really functions within the UN system is the International Court of Justice. And at the same time, the states concerned are asking the court to address issues that have not been resolved by the Security Council, which is blocked by the veto system. I mean, if ever the Security Council does manage to take a decision, it adopts resolutions that are all too often found wanting. Otherwise, they wouldn't be adopted if they weren't found wanting. The effects of the veto system have been known for a long time. In fact, entire libraries could be filled with studies and reports and proposals for reforming the UN Security Council. But the outbreak of war in Ukraine, in defiance of the fundamental rules of international law, has really thrown the spotlight on this paralysis of the UN Security Council. It's thrown the spotlight on it, and it would appear that the whole UN system is powerless. And yet it would be up to the Security Council to try to get Russia to suspend its military operations in Ukraine. It would be up to the Security Council to try to get Israel to halt a repression of Hamas that is causing unacceptable suffering to a considerable number of civilians. It is, of course, by no means incongruous that the court should also be asked to give its opinion on the matter, although in some cases one might wonder whether the court is not being instrumentalized by the states, given the current circumstances. But the fact of the matter is that the Security Council is not exercising its primary responsibility right now. And this strikes me as extremely serious, because it's a sign that the 1945 system has become obsolete. It was established in 1945, 51 states, the victorious states, of course, you shouldn't forget that. The United Nations was an organization set up by the victors. Since then, of course, it has expanded, new admissions, it's become much broader than that, but initially it was actually an organization set up by the victors in a very specific set of circumstances. Things have changed since, a lot of water under the bridge since. But I think time has come to revisit this system because it really is being called into question. And it is a questioning that goes deep. Basically, we are challenging, or some are challenging, the very values that underpin the whole system. Instruments that were inspired by a philosophy known as the Enlightenment, developed by philosophers, mainly, but not exclusively, French philosophers, and also by the founding fathers of the United States system. I think it's worth noting that the period of European domination was relatively short. I think it should be noted it was relatively short. We're just talking about a few centuries. And that period also obscured from view the great ancient civilizations of China, Persia, Arabia, or the great empires of the Incas, Ghana, Mali, and I'm just naming a few. There are many, many others besides. The questioning also occurs against the backdrop of waning Western influence, the ascendance of Asia, the emergence of new constellations such as the BRICS group of countries, which are expanded on the 1st of January of this year, very recently. Egypt, Ethiopia, Iran, Saudi Arabia, and the United Arab Emirates. They're not small states. They're not small states. These are weighty states from a political point of view, from an economic point of view. They carry a lot of weight. And yet, notwithstanding all of the above, I'm certainly not one of those who would say that this is the sign of Western decline. Now, you would say, well, of course you don't, because you're Western. You're a Westerner yourself. But nevertheless, I really don't think that this is a sign of Western decline. What I do think is that the most appropriate thing to do right now would be to, so to speak, share the cake, to do it more fairly. The integrity of the cake, of the pie, must be preserved, but we should share it out more fairly, more equitably. And then, moving forward, it would be better for the international community as a whole to advance together towards a common goal and to do that in a spirit of solidarity. I'll come back to this in a moment, but at this juncture, I just want to make the point that this approach is the only viable one. You might think this is, impossible, that this is just a figment of my imagination. Nothing will come of it. And yes, I concede that it is a difficult approach, but it's the only viable one. Like it or lump it, it is the only one that will guarantee our survival. If we want to overcome, as best we can, the global challenges of this century, global challenges by which I mean climate change, environmental change, health risks, migratory movements. We haven't spoken about this yet, but I would also like to remind you that this is just the beginning of migratory movements. This is just the beginning. We'll have to see what happens over the next few years. We haven't seen much at this juncture. And I think we need to also use a completely revisited approach towards globalization. We need to be mindful of the fact that these global challenges do not stop at borders. They don't care about borders. They don't stop at borders. Now, unfortunately, challenging the rules is not helpful in terms of generating this momentum that I believe we need here. Now, coming to the point of challenging the rules, what do we mean by that? Perhaps I should say a few brief words on this phenomenon of challenging existing international law. In some respects, you might argue that the phenomenon is not new by any means. Some 60 years ago, an initial general challenge to the rules of international law in force was mounted in developing countries, countries that had just gained their independence in the 1960s of the previous century. And these countries were demanding that the rules be better adapted to their specific needs. This movement was expressed in the so-called 4 development decades, adopted by the UN General Assembly between 1960 and 1990. The legal experts of the Group of 77, and first and foremost Mr. Mohamed Bejawi, who went on to become president of the ICJ later, and large swathes of Western legal scholarship all supported this demand. I myself very much supported this movement because we believed that this could actually translate into a rereading of our international law rules, but applying this time a new lens, a development lens. So we would take the rules, take a look at them, and reread them, but applying a development lens. And that would allow us to advocate a number of principles, some of which have been applied, the principle of a duality of rules, or indeed a compensatory inequality. And again, it wasn't something completely new. Aristotle had already thought of this many, many years before. So nothing new under the sun, so to speak. It was a fine philosophy, and it had history. So we're talking about applying common rules in a common system that would be known as international development law. That was the idea at the time. And criticism of traditional international law may indeed be viewed as an effort to find common values, a policy of protection, of coming together, and ultimately of solidarity. These values are in fact foregrounded in the international social law developed by the International Labour Organization, the ILO. In this work, the ILO is complementing the interstate approach of development law by taking more direct account of individuals. International social law, or international law on social rights, seems to me to have been strongly marked by moral concerns, with pride of place given to solidarity, a reflection of the type of social solidarity that you'll find in domestic social law, which includes special protection to be afforded to weak or disadvantaged population groups or weaker parties to a contract, etc. And this is seen as the bedrock of intersocial and intergenerational relations. So these are the movements of the first generation, I would say. Movements dating back a few years now, the first generation movements, but I see a marked difference between these movements and the positions defended by the Twales more recently and other schools of thought, which are critical of positive international law. International law is perceived as Eurocentric, colonialist, masculine, and white. Need I remind you that Russia's official position, for instance, is that it has nothing to do with Europe, which always seems strange to me. I've been to St. Petersburg. I went to visit the Hermitage Museum, and I didn't think that I was that far from my own roots. But anyway, be that as it may, and whether or not you support these movements, you have to listen to them, and you have to take them seriously. All the more so since they seem to me to be less concerned with the existence of an international community and less driven by moral concerns like those of the first generation, and more inspired by a powerful demand for the establishment of new paradigms, which would include a reparation component to be borne by the former colonial powers for the damage caused by colonization. Some cases are indeed emblematic in that regard. I would mention Haiti in particular, an emblematic case. a state gaining its independence and damages being called for. This new international order would be more fair, but it would be stripped of the trappings of classic international law. But this new international law is not necessarily based on solidarity, and it is forcefully denounced. Its rules are considered heavily biased. The criticism is absolute. The criticism isn't necessarily universally shared, which suggests that there might be some scope for less radical formulas. Now, I've only been able to say a few words about different examples, but I do wonder, is international law international? Is that a wholly unreasonable question to ask? Is it to ask, is international law international? I mean, at the risk of sounding hopelessly conservative and close-minded, I actually think that today what's urgent is not to try to antagonize different groups, but rather what is urgent is to try to serve the international community as a whole. So this is the alternative perspective, the one that I propose to address next. What is the effort that we need to make in order to implement this solidarity? You may remember that at the beginning of this speech, I mentioned the fact that I rather liked the term solidarity. It has a sort of peace and love feel about it. And of course, that is not the situation that prevails in the world today, it has to be said. What's more, I am aware of the fact that the term is conducive to some confusion. Oh dear, I haven't finished at all. I'm nowhere near the end of my speech. Perhaps that was a mistake. Perhaps that was an error. Ah, yes, it was an error. I do apologize. I thought I was way over time, but I wasn't. I have a good time left to speak. So, like I said, solidarity evokes peace and love, not the situation that prevails in the world today, and it also is conducive to some confusion. And you must always be aware of this confusion between lex lata and lex ferenda. Solidarity is like any other moral rule, if you will. We would like to see it permeate international law, thereby helping to humanize international law. And certainly, there are links that could be forged here between solidarity and human rights. So solidarity could be brought closer to human rights. And solidarity could also contribute to the humanization of international law, a very strong trend that we've seen in recent years. Look at the International Court of Justice, the human rights conventions. Look at the work being done there. Many justices. There are those who no longer sit on the court, but Dame Rosalind Higgins, for instance, or Judge Sima, Counsel Trindade, of course, and many others besides. Many of them have made a contribution to the human rights dynamic developed in this field. And the idea is not novel as such, but the idea has now expanded well beyond the realm of legal scholarship. However, it has not yet reached a stage where solidarity could be seen as a principle of international law. I don't think we can say at this juncture that it's a principle of international law. In other words, I find it a little bit difficult to follow Professor Karel Wellens, who's done some very interesting work on this and who suggests a sort of three-step progression from the law of coexistence to the law of cooperation and culminating in the law of solidarity. Coexistence, cooperation, solidarity. Intellectually, this is very appealing as a thought, but I think that the idea goes too far, at least in my opinion. In my view, solidarity faces certain obstacles to being recognized as a principle of international law, obstacles that stem from the discipline itself. Having said that, as a necessary moral principle, solidarity may well serve as a source of inspiration for general international law. What are the obstacles that I see? I see two, which are difficult to overcome. The first one has to do with a lack of a genuine international community to speak of. And the second, which is linked to the first, is the principle of sovereignty, which also acts as a lock, if you like. The absence of an international community was quite rightly flagged by Justice Tladi, who was recently elected member of the court, having noted the inability of international law to meet current challenges, such as poverty or inequality, which stems from the failure to integrate solidarity into the international legal order. Having done that, Justice Clady then asks whether an international community really does exist, bearing in mind that it is a necessary element for the aforementioned integration. And finally, Justice Clady argues that this movement will not come about naturally. The movement will require a proactive approach. And I would agree with Justice Clady on this point. Admittedly, of course, the court does use expressions such as international community or the international community as a whole, and these are terms that also form part of everyday diplomatic language, but without much guidance as to the existence or indeed the importance of a difference between the two expressions. I'm afraid I don't have time to go into this oft-debated question with which I'm sure you're all familiar, but I think I'm right in saying that the adverbial phrase as a whole tends to refer to situations of great importance involving erga omnes obligations. I would refer you, for instance, to the Barcelona traction decision, or indeed relating to Jus Cogens norms. Here I would refer you to Article 53 of the Vienna Convention, with which they are in harmony and in which it is the common will of the whole that is expressed. The same formulations, international community as a whole, also relate to specific areas in which all are effectively concerned. Outer space, for instance, or the seabed, or the climate, etc., etc. Furthermore, NGOs are undoubtedly also concerned, and most certainly individuals too, in and of themselves and as future generations, hence the use of the related expression humanity or humanity as a whole, even better. I can't quite see the difference, by the way, between humanity and humanity as a whole. I fail to see the difference, but sometimes we like to emphasize it, so we say humanity as a whole, to really emphasize the point. And furthermore, you will find such references in some of the provisions of the Convention on the Law of the Sea. But for all that, we also know that this international community has no legal existence. It's not a subject of law, and it cannot act on its own. It can only act through states and possibly through international organizations. And yet, only an international community with legal personality could introduce a principle of solidarity as such into the international order. And the international order, by the way, would be completely overturned by this, because it would be based on a pillar that finds its natural place in domestic orders, state orders or otherwise, in these domestic orders where a common will is expressed by representative institutions that routinely embody this solidarity. The current circumstances prevailing in the international community really don't fit this model. And this model is therefore not conceivable, and I would even say it's not even really desirable, because it would actually contradict the principle of sovereignty. Nobody wishes to abandon the principle of sovereignty. At a push, we might be prepared to consider adjusting it. Having said that, the principle of sovereignty does not exclude solidarity, of course not, but it may find itself in tension with solidarity under certain circumstances, where solidarity will try to bend sovereignty to its will, even if sovereignty is pretty robust. One of the best or most emblematic examples of this is the responsibility to protect, responsibility endorsed at the 2005 World Summit to protect populations against the most serious crimes: genocide, war crimes, ethnic cleansing, crimes against humanity committed by one's own state, or crimes which one state has failed to counter. Please note that natural disasters are excluded from the scope of this provision. Now, unfortunately, the war in Syria and Russia's support for the Syrian regime after the use of chemical weapons in 2013 marked the failure of this responsibility to protect. This fine concept was essentially sidelined. Now, a few years earlier, Professor Boisson de Chazourne, whom I greet in the auditorium, had very clearly, very convincingly demonstrated the connection, the articulation between the notion of solidarity and sovereignty. There is a match between the two. I've called it correspondance in the French. I'm not sure that that is perhaps the right word to use in French, but there is a match between solidarity and sovereignty. A match. We can discuss that further if you so wish. However, sovereignty has not yielded. It has not yielded ground. And as I'm sure you'll understand, if a state fails to protect its own population, or if it mistreats its own population, it would be difficult to imagine that state allowing other states to act in its place in the name of an international community or in the name of a principle of solidarity. Several of the examples that I have shared with you reflect an effort to make international law richer by introducing common values, common interests, with which everyone can identify equally, regardless of whether or not they are the subject of protection. They provide an image, perhaps a direction of travel, towards a better, more moral, more humane international law, an international law that holds out the prospect of happier times ahead. And this is by no means an insignificant advantage, and it certainly gives traction to any efforts to let solidarity permeate international law to whatever extent possible. Obviously, good sentiments, and nothing prevents us from expressing good sentiments, they are not in and of themselves enough to transform the rules that govern the world. And yet, when talking about the necessary reconstruction of principles, rules, and institutions, some of whose obsolescence I've tried to show you, in that approach we need to adopt a realistic position. We need to adopt an approach that is based on conciliation and not on confrontation. Essentially, what I'm talking about here is a balancing act between solidarity and sovereignty. Let me take an example that I think perfectly illustrates this point, the example of natural disasters. Now, unfortunately, we cannot rule out the possibility of climate change fueling the expansion of natural disasters, of more such disasters occurring in the future. I don't think I need to dwell on the way in which natural disasters make us feel, even if we're not the primary victims of these disasters. And indeed, state aid is deployed on the basis of solidarity when natural disasters occur, either at the request of the benighted country or as a spontaneous offer for the benefit of the victims in the affected state, with which, by the way, relations may not be that good, generally speaking. But the offer is made. In 2003, when the Bam earthquake struck Iran, President George W. Bush expressed his compassion and his solidarity with the victims. And the United States, which had not been present in Iran since 1980, sent several tons of emergency aid and several dozen doctors and rescue workers to Iran. Sanctions were also partially lifted for a period of 3 months. So, in other words, Iran benefited from this humanitarian aid, which was deployed out of a sense of solidarity on the part of the United States. Now, let us not be naive. We need to be aware of the fact that there is always a more or less obvious political agenda behind this type of situation, and Americans are not innocent lambs after all. But nevertheless, the principle of solidarity was implemented in that case. On the other hand, Iran declined an offer made by Israel for reasons that are easy to guess. The same happened with Morocco and France after the recent earthquake in the region of Marrakesh. And indeed, for a number of reasons that I don't think we need to explain here and now, relations between Morocco and France are currently going through what one might call a rocky patch. In addition, it's probably also a question of positioning, given France's history, given the colonial protectorate lifted in 1956, 65 years ago, in other words. So, as you can see, even in situations that typically involve human solidarity, or to use the court's famous phrase in the Corfu Channel case of 1949, to speak of elementary considerations of humanity, which are even more absolute in times of peace than in times of war, well, even in such circumstances, the principle of territorial sovereignty may come into play, and solidarity is neither pure nor unblemished. Having said that, in 2016, the International Law Commission adopted a draft on the protection of persons in the event of disasters, the preamble of which, in my opinion, reflects this delicate balance rather well. It's a subtle balance between the terms, and it uses the following terms. Number one, recognizing that solidarity is a fundamental value in international relations, and the importance of strengthening international cooperation in all phases of disasters. Number 2, emphasizing the principle this time, principle of state sovereignty, and reaffirming, therefore, that the state affected by a disaster has the primary role in the provision of relief, etc. And then I come to Article 13, which is entitled Consent of the Affected State to External Assistance, which provides in its paragraph 1, the provision of external assistance requires the consent of the affected state, and then in paragraph 2 it says, consent to external assistance shall not be arbitrarily withheld. So, in my view, this is a very skillful and effective way of introducing solidarity into international action in a fair and balanced manner. And I wonder, therefore, whether the key might not lie precisely in a compromise between solidarity and sovereignty. I wonder whether, instead of seeing their relationship as antagonistic, like fire and water, whether we shouldn't instead seek to combine them. We live in a world of interdependence, interconnections, mutual influences, including cultural influences, and news, and unfortunately also fake news, circulates at the speed of the internet itself, where the flight of a butterfly in the Bay of Rio, assuming that there are still butterflies in the Bay of Rio. Anyway, flight of a butterfly in the Bay of Rio, well, it seems that its action will apply to all human activity wherever it might occur. And in such a world, the sovereignty fortress of times gone by is no longer relevant. Would it be possible, therefore, to discern on the horizon the emergence of a sovereignty made more flexible by a principle of solidarity? The war of aggression against Ukraine is a good illustration of both the existence and the limits of solidarity. The existence of solidarity initially marked by very broad agreement to condemn Russia at the United Nations General Assembly and also at the UN Security Council. It was only the Russian veto that prevented the resolution from being adopted by the UN Security Council. Everybody else agreed. But there was a veto. There was also solidarity within the European Union, which was able to close ranks on this occasion, overcoming its divisions, presenting a united front in its first decisions on sanctions. Solidarity within NATO, too, expressed in an extremely firmly worded declaration by the heads of state and government. Finally, solidarity with Ukraine in various forms of humanitarian assistance provided by states, NGOs, associations, as well as individuals. But this support has its limits. Economic sanctions, however broad they may be, have sometimes been weakened, undermined, or indeed completely sidelined by some states. Some states who, even though they are members of the Union, are also minded to protect their own economic interests, which are considered essential. This, in turn, undermines European unity. And as for moral and humanitarian solidarity, once the moment of shock, compassion, and empathy has passed, the passage of time is a formidable threat to its persistence, or indeed conflicts occurring elsewhere. This really is a threat to the persistence of solidarity. Finally, and this is perhaps one of the most important aspects, although it's rarely highlighted, we must be wary of looking at the situation through a Western lens. The strength of anti-US sentiment, defiance towards the colonial West are such that behind the very general, albeit not unanimous, condemnation of Russia's aggression, behind that there is perhaps no real support for Western policy in many of the countries of Africa, Asia, or Latin America. And I could, of course, expand on that point further if I had more time. So, the permeation of a principle of solidarity into the fabric of international law, and I come to my conclusion, is a subject on which legal scholars really must reflect, not only for moral or humanist reasons, which would be perfectly respectable in and of themselves, of course, not only because of that, but simply because of the nature of the crises that we are currently experiencing. These crises must not be allowed to thrive in a place from which they would come to threaten the whole. In a way, solidarity is the flip side of the general interest, which in turn is the flip side of security, another face of. And therefore, in these times of deep crisis, we need to be showing solidarity for all of these reasons. We're talking about health issues, environment, migration. We need to think outside the box, be imaginative. We need to propose solutions to a world that is interdependent. We need to respond to the legitimate needs of international society for solidarity. We also need to bear in mind international society and its needs, and compromise formulas should therefore be found between these two needs, sovereignty and solidarity. I think it would be hard to see how we can overcome our difficulties if we do not rethink the concept and the legal regime of sovereignty to ensure its greatest possible compatibility with solidarity. Sovereignty has evolved over time. A lot of time, a lot of water under the bridge since the concept first emerged. But perhaps the time has now come to give some thought to something that we might call collaborative sovereignty. Jacques Delors, who was a great European who passed away recently, a great European who famously drew a distinction between competition that stimulates, cooperation that strengthens, and solidarity that unites. Ladies and gentlemen, I would ask you to mull over that particular quote, because tomorrow you will be the ones in charge. This is the last time that I have the great pleasure and honour to address the auditors of the Hague Academy. It has been a great pleasure for me to attend, in particular, the winter courses. At the time, I was Secretary General of the Hague Academy, and this idea actually came from my own thoughts. I thought, why not organize winter courses? Why not? It was my brainchild. I sounded out a number of people. This was the year when James Crawford was given his general course, and at the time there were quite a few Australians in the room, perhaps a few people from New Zealand too. And we sounded them out. What would you think? What would you say if we had a winter course? I mean, at a time of the year when you are on holiday, because of course there's, the southern hemisphere is not on holiday at the same time as the northern hemisphere. So let's not forget that. There are many countries in the world that are not affected by northern hemisphere holidays. And the response was, what a great idea. They said, well, we often spend, for instance, holidays with family in the UK. We come for Christmas holidays, and before returning to Australia or elsewhere, we might then go to Switzerland, do some skiing in the Alps, stay around a little bit longer. And I thought that was an excellent motivation, an excellent opportunity to seize. And therefore, I launched the idea of the winter courses, and lo and behold, they did occur. And that's why I set particularly great store by this program, the program that you will be following these 3 weeks. And of course, the Secretary General had to do all the work. I mean, I came up with the idea, and ideas are fine, but actually implementing the ideas is the real hard work. And the current Secretary General is the one to have actually set up the courses, got them up and running, which is a formidable amount of work. So all praise. I'm very grateful to my colleagues from the Curatorium. I would like to thank you very much indeed for inviting me to give this inaugural lecture. It's the last opportunity, like I said, a last opportunity for me to speak to you all, and to do so in this amphitheatre, this auditorium, because my term of office will come to an end at the end of January, so just a few days' time. I'll reach the end of my mandate. I've spent approximately 20 years with the Academy. I will be leaving next week, and I will be desperately sad to do so, because they were some of the happiest, most beautiful days of my life as a professor, meeting with brilliant students coming from all corners of the world, from everywhere. It's been such a joy to meet with you, to exchange with you. You've all given me something. So to thank you, I would like to wish you the best of success from a personal point of view, from a professional point of view. I wish you all the best. Happiness is composed of both, and we need to do this in a spirit of solidarity. Thank you for your kind attention.